Right, good morning. Sorry for a slight delay there. Let's move on into the programme per se. What are we going to be covering in this session? Well, we're going to be looking at data security, the DSPT, and the recording processes that are required for both of those elements. So what we're going to be looking at is the Information Asset Register, or IAR, your Record of Processing Activities, or ROPA, and your DPIA, or Data Protection Impact Assessments. All three of those are requirements for the GDPR and data protection legislation requirements and for the DSPT. So what we're going to be focusing on is how important are these elements and what do you need to know in order to be able to meet those requirements in relation to these areas. So just to put it into context, this programme is part of the Better Security, Better Care programme, which is funded by the Transformation Directorate at the NHS. And its overall aim is to make sure that social care providers have good data and cyber security in place. So it's nothing more complicated than that. And in essence, the primary drive is to help care providers to complete the data security and protection toolkit, which is the best practice element of your expectations around these areas. And then finally here you can see that there is a link through to the Digital Care Hub, which is where there is the main repository of resources and information around anything digital and social care. So what are we going to be covering during the session? First and foremost, by way of context, what we're going to look at is the law and data protection. What does it actually say you should do and how you should do it? And then following on from that, we'll look at the regulatory expectations. So if you are a CQC registered service, what does CQC say about all of this stuff, and what will they be looking at under their new assessment processes, etc. And then in order to be able to assist you to meet those expectations in relation to this area, we're going to look at the ROPA, IAR, and the DPIA in relation to what it is and how can you actually do it. What do you need to do in order to fulfill those expectations that we've been referring to? So let's start with having a look at data protection, GDPR, and what they actually say and how that relates to the key three themes for the session. So data security and protection legislation is primarily about the proper and fair use of information about people. So it's about protecting people's personal data and privacy. And just want to emphasize that it's not just confidentiality, that it's much broader than that. It's about what sort of data we've got, how we use that data, and whether we do that appropriately and openly and fairly. And indeed, in social care, sharing information is a legal requirement, so it can't just be confidentiality. And it's primarily about people's fundamental right to privacy. So it's about building trust between your organisation and the people that you support, ensuring that those people can trust you to use their data fairly and responsibly, and that you treat those people fairly and openly. And ultimately, it's about recognizing the right that they have to control their own identity and interactions with others in relation to the data. So the legislation is there to make sure that all organizations who handle personal and confidential information do all of those things in an open and fair way. And in relation to whether it covers care services, any organization that processes personal data is subject to this legislation. Therefore, it catches most businesses and organizations regardless of size. So where does it state what you've got to do and how you need to do it? Well, it's within the Data Protection Act 2018, which since our exit from the European Union now includes the General Data Protection Regulations, or GDPR. And I really want to emphasize that this legislation covers all data. It's not just electronic data and information. If you are still using paper records, etc., then the legislation applies equally. The legislation is enforced by the Office of the Information Commissioner, or the ICO, and the ICO is there to make sure that all organisations that handle that personal confidential information do so in accordance with that legislation and regulation. So that's how it's supposed to work, that it's there in order to protect people's personal data and privacy, and there is someone who's monitoring what people do and how they do it in relation to that. However, the legislation is quite interesting because it doesn't work in the same way as many legislative requirements. In order for it to be able to cover as many organisations as possible, it actually adopts an approach based on key principles. And it is for the organisation to determine how those key principles apply in their reality. So rather than specifying, you must do this, you must do that, it says, this is the overarching principle of the legislation in order to achieve those objectives. And it is for the organisation to determine how to respond to that overarching principle in relation to the personal confidential data. So the starting point to understand how you can interpret those principles and apply them within your setting is to understand what personal data actually is. And personal data is anything that could directly or indirectly identify someone or the data subject. So that could be contact information, employment details, training records, etc. So it's a very broad scope in relation to personal data. If you can work out who that person is that this data or this information is relating to, then it's personal data. So that could even be social media. It doesn't always need to include a name, a payroll number. So an email address could be sufficient to identify someone. Therefore, it becomes personal data. And within the legislation, there are two categories of personal data. There's ordinary personal data that applies to the first paragraph that we see there. So if we're able to directly or indirectly identify someone, that becomes personal data. But there is also an additional category of particularly sensitive data that we need to be particularly careful of. And there are additional requirements under the legislation in relation to that sensitive data or special category data that we hold. So in short, personal data means information about a particular living individual, and that could be anyone, including a customer, client, employee, partner, member, supporter, business contact. And it's about, the legislation covers the processing of that personal data primarily. And processing is the collection, storing, organizing, or doing anything with it. So if we hold and then use data, it becomes subject to the legislation. So moving on to the special category of personal data that we need to be particularly careful of, that's anything that relates to race or ethnic origin. It's anything to do with political opinions, religious beliefs or other beliefs of a similar nature, whether or not people are members of a trade union, any genetic or biometric data for identification, physical or mental health or condition, sexual life, and criminal convictions. So if the data that you hold falls into any of those categories, it is deemed to be sensitive personal data, and there are, as I said, special or additional expectations in relation to what we do and how we use that information. So if we look at that series of definitions there, we can see that a number of those are the very nature of social care. So people's race or ethnic origin, religious beliefs, our sexual life are the sorts of things that we gather routinely in order to be able to provide holistic services. Moving into some of the other headings, we can see that physical, mental health or condition is the very nature of the reason why the person is probably engaging with our organisation overall. And then criminal convictions, we have a legal obligation to gather information on staff prior to their employment. So clearly, in a social care environment, sensitive personal data is routinely gathered and processed in order to deliver the services that we deliver. So we need to be aware of the difference between what we have that's ordinary personal data and what we have that's sensitive personal data, because again, there are those additional expectations. So in order to determine whether or not you are doing what you need to do in relation to those requirements, let's have a quick look at the key principles within the legislation. So the first of those is lawfulness, fairness, and transparency. Well, in relation to the last of those, the transparency, we need to tell the data subject what data processing we are going to do with the data we hold about them. So we need to be open and honest about that. So this is what we've got, this is what we're going to be doing with it. And what we do with it must match up with how we've told them we're going to do it. And in relation to the lawful element, the processing must have a valid legal basis. So we must be able to identify what's the legal footing upon which we are doing what we're doing with this data. And that could be consent, or it could be one of the other categories within the Schedule 9 definitions, etc. So we need to be able to identify what we've got, what we do with it, and why we do that with it. And we need then to tell the individual about that in order to meet the first of the key principles. And the legal aspect of what we do with that information is one of the key elements within your record of processing activities. So it's really important that you're able to identify what lawful justification you have for using that information. The second of the key principles is purpose limitation. So we can only obtain personal data for specified, explicit, and legitimate purposes. And we can only use it for the specific purpose that the person has been made aware of, and nothing else. So we can't just decide to do something with the data just because we feel it's convenient or helpful to us. We have to have told the individual that that's within the limitation of the purpose for that data. The third key principle is data minimization, that any information we collect on a data subject should be adequate, relevant, and limited to what is necessary in relation to the purpose for which they are processed. So having identified what we've got, what we're going to be doing with it, we can only gather the information that is relevant to that use. So we can't just gather more information just in case it might become helpful. The data that we hold also has to be accurate. And where necessary, it must be kept up to date. So where it's changing and where it's critical in terms of accuracy, we need to make sure that it is both correct and that it is up to date. Excuse me. So data holders need to build in some form of rectification process into your data management and archiving activities so that people can check what data we hold about them and if it is accurate and if it meets the information that we give them under the first of the key principles. The next of the key principles is storage limitation, and that means that we can only keep information that allows identification of the data subject for as long as is necessary for the purpose for which we've gathered it. So therefore we need to have some kind of retention schedule that tells us when that information is no longer required and when we need to destroy or dispose of that information. And we need, within that process, to identify an appropriate and safe way of doing so. And all of these elements are what we need to understand in order to be able to complete the information asset register and the record of processing activities. And then lastly, the final key principle is integrity and confidentiality. So whatever data we hold, whether it's ordinary personal data or whether it's special category data, it must be secure and confidential. And again, within the information asset register and the ROPA, we need to be specifying what we are doing to ensure that. So we need to have good IT systems in place if we're using digital storage means, and we need to have safe paper records if we're using paper data storage. So to summarize all of that, to be compliant with data protection legislation, we need to know what data we have and how we use it, and we must have a written record of that, and that's your information asset register and your ROPA. We need to know why we have it, who we share it with, where do we get it from, and where do we send it. Again, that's information for those two documents. We need to know when we should destroy it, and that's again within those records. We need to understand who has access to it and that those people have had the appropriate training for the appropriate level of access that they have. And we need to know how it's stored and whether that's safe and secure and what measures we've put in place in order to ensure that. And again, that's whether it's paper records or digital systems. And just to make a plug for the DSPT, all of this is what's contained within the DSPT, which is why it's your self-assessment against the legislation, etc. However, those are the requirements, but there are also some rights that are bestowed upon the data subjects. And the data subjects have a set of individual rights provided by the legislation. So they have the right to be informed, as we looked at with the key principle. Part of the transparency element is that we tell people what we've got and what we do with it. So we need to provide them with something called privacy information, which is around what information we've got, what are the purposes for processing that, how long we're going to keep it, and who it's going to be shared with. And that's normally provided within a privacy notice, sometimes within the contracts that we have with clients, etc. The information that we provide within that must be concise, transparent, intelligible, and easily accessible. So bearing in mind within a social care environment, we're often working with people who have limitations in relation to their ability to assimilate information. We need to think through how we're providing that information in a way that they're able to access, whatever that might be, depending on the client group that we're working with. The second of the rights is the right of access. So having told the individual what information we've got and what we're going to be doing with it, etc., they then have the right to see that. And they have the right then to ask us to change some of it, the right to rectification. So if they're not happy or they believe that it's inaccurate, they have the right to request that. They also have the right to ask us to remove it if they don't want us to have it, which is where the legal justification for having and using this information becomes really important, because if we're relying purely on consent, then they can ask us to delete all of the information we hold, which in most circumstances may well mean that we're unable to provide the service that we're providing. So we may need to think of some other legal basis upon which we're relying on the collection and processing of their personal data. Which brings me on to the next of the rights, which is the right to restrict processing. So having been told what we've got, what we're going to be doing with it, the individual has the right to say, well, that's okay, I'm happy for you to use it for that, but I don't want you to use it for that. Again, the legal basis upon which we're using the information needs to be thought through. And then particularly pertinent at the moment is the right to data portability. So part of the integration of health and social care and the joined up working, etc., is about facilitating that right, that once they've given the information to one organisation, they should be able to carry that information throughout their social care pathway without having to continuously repeat that information. The seventh of the rights is the right to object to processing at all. And then they have rights in relation to automated decision-making and profiling, which is less important in terms of a social care environment because we don't often do that sort of thing. So that's all of the rights, all of the legislative requirements, etc., that feed into and dictate how we work with the information asset register and the record of processing activity. So if we don't comply with that, what can happen? Well, under the Data Protection Act, there is a maximum fine of 500,000. Under GDPR, 4% of group turnover, and a failure to let the Information Commissioner know that we are processing personal and confidential information by registering with them means that there is a potential of a £4,000 fine for not registering. So there are some serious consequences under this legislation if we don't do what we should do. Does it happen? Yes. So a chemist was fined £270,000 for leaving documents containing special category data in unlocked containers outside the back of its premises. The important thing with that example is not necessarily the fine, but it is that they were fined even though there wasn't a data breach. So no one accessed that data, but the potential for them to access it was there. Therefore, it was a breach of their legal requirements. Similarly, the NSPCC fined for using a form to collect personal data. However, what they didn't do was tell the people they were collecting the data from that they would be using that for marketing. So there was a failure to tell them every element that they were going to be using the data for. Another key principle in relation to compliance is within the next example, where a GP practice manager prosecuted for sending personal data to her own email account without authorization. And there was nothing sinister within that. The practice manager merely wanted to work on the data outside of work hours. However, by sending that data outside of the protective framework that they'd set up for data protection, it was a breach of the legislative requirement. Similarly, nurse at an NHS trust prosecuted for repeatedly accessing medical records without authorization was a breach of the requirement that people should only have access to data that they require in order to fulfill the job that they are employed for. And Bupa was fined for failing to have effective security measures in place to protect customers' personal information, which kind of summarizes all of those. That the legislation means that we must do these things, and that a failure to ensure the security of personal and confidential information in any way, shape, or form means that we are in breach of those legal requirements. So that's the legislative context. That's the implications of not fulfilling those legal requirements. And then let's have a quick look at what CQC want. So they state that they will check the way you handle personal information meets the right standards. So that's GDPR, Data Protection Act. It's also the National Data Guardian standards, which are written specifically for health and social care, which broadly speaking reflect the requirements within GDPR. However, they very specifically identify some additional requirements, and indeed DSPT is written around the National Data Guardian's 10 standards. So if you assess yourself using DSPT and you meet all of those expectations, then you are fulfilling the National Data Guardian standards. They also talk about other codes of practice, and here we're talking about lots of the digital requirements if you use digital social care records, etc. So I'm conscious that CQC have been changing in terms of where they're going and what they want. So moving away from the key lines of inquiry, I thought I would look at the single assessment framework and what CQC say within that. And under their quality statement, governance, management and sustainability, they set out very clear requirements that relate to the data and cybersecurity elements of your business. So they expect that staff understand their roles and responsibilities. So within that is their data protection responsibilities and upholding those rights that we looked at within GDPR. And then you can see that they require that there are robust arrangements for the availability, integrity, and confidentiality of data. So all of those expectations under the key principles that I talked about. So whatever you use in terms of your data management systems, they must be available to the appropriate people, they must be accurate and up to date where necessary, and they must be kept confidential. And then in relation to the leaders, they state that they should implement relevant or mandatory quality frameworks, recognized standards, best practice or equivalents. And all of that, again, is about the National Data Guardian's data standards. And all of that, as I've said, is within the DSPT. So as subtopics of that quality statement, I've highlighted in red here all of the bits that I think relate to what we're talking about this morning. So roles, responsibilities and accountability, governance, quality assurance and management, cyber and data security and protection toolkit. So DSPT is specifically mentioned within the quality statement. Emergency preparedness and business continuity planning is part of the DSPT. Then moving on to data security, data protection principles per se, your statutory and regulatory requirements, which relate to everything that we've talked about so far, and then records and digital records. So clearly, within this one quality statement, it covers everything that we've been talking about so far. So how can you actually ensure that you're meeting the legal and the regulatory expectations? Well, clearly the DSPT, and I've mentioned that several times, so I'm not going to be going into great detail on that as we speak. So moving on to the requirements within all of that, the Data Protection Act, GDPR and DSPT compliance, and therefore CQC. In order to meet all of those, you're going to need an information asset register, a record of processing activities, and carry out data protection impact assessments as and when that's necessary. So how can you actually do that? Well, looking first and foremost at what is an information asset register. In essence, it's a list of all the places where information is stored, whether that information is special category information, we looked at what that is earlier, and how you keep that information safe. So to summarize, it's what you've got and where you keep it. So any information that meets the criteria of personal data, you need to recognize A, where it is, whether or not it is special category information, and how you take your responsibilities seriously in terms of keeping that safe and secure. So you need to have a record of all of that. That is the information asset register. So how do you go through the process of collating an information asset register? Well, firstly, you need to think about how you're going to record that. And there are templates available on the Digital Care Hub. And I've based what I'm sharing with you this morning on one of those templates, but it can be in any format at all. So depending on the size of your organization, it's horses for courses. Do you need a massive Excel spreadsheet, or can you do it all on one side of A4? It's entirely up to you, providing you cover what it needs to cover. So deciding on the format is the first step. Then you need to gather your key information and cross-check that you've covered everything that you need to cover. And then insert it into whatever template you're using, and then complete any other information that relates to that. And whatever you do, you need to make sure that whoever is responsible for data protection within your organization has approved that particular information asset register. So what do you need to do? So I would suggest that the first thing you need to be doing is listing all of your information assets. So what have we got? Where do we keep it? How do we keep it safe? And then follow through the cycle that's on the slide there. So once you know what information asset you've got, what information is there and why you keep it, where do you keep it, and how do you keep it safe? And those are the four key elements of your information asset. So I would suggest the sorts of things you need to be doing is walking around your building office, depending on the size of your organization, check that all information assets are listed. And then you can use the checklist to make sure that all personal information is allocated to a specific information asset. So then I would suggest that you need to be thinking about 4 key areas that you want to think about. So what's the information asset name? And you need to be grouping all information you hold in the same place. So for example, staff information records file could hold all the personal information about staff. And you need to think about the various formats that you have that in, whether it's paper, CD, electronic, tape, USB, cloud, wherever it is. Then you need to be describing the sort of the information that you keep in each information asset and why you keep it. So we're looking at what information we've got, what is the nature of that information, and why have we got it? And then the next element we need to be thinking about is where is that information asset? So is it in the filing cabinet locked, or is it in a specific folder on your computer? And then identify the security measures that you've put in place to keep that safe. So whether that's password protected, two-factor authentication, or whether it's just simply locking the filing cabinet, etc. So here are some examples of information assets that could be holding personal information. So we've got cupboards, filing cabinets, devices. So you can see it's at high level. It's not the individual care records. So we don't need to be identifying each service user's care record. We need to be having that under the heading of care records and where that is. So thinking about some examples on the right-hand side here, you can use something like this to check off that you've covered everything that you need to be thinking of. So your care record filing system, is it paper, computer, smartphone, iPad? Are they relevant or not? Lists of residents' names, room numbers, birthdays. What devices do you use? Computers, laptops, mobile phones, etc. You can read through the examples yourself on the slide. But the important thing here is that what we do is capture all of the information assets that we have and make sure that we've thought through what we've got within them and why we've got that. So then we can start inserting the information in whatever template we might be using. So the information asset name, if it's provided from a supplier, who they are, is there a contract with that supplier? What information is kept here and why? So you can see the stars indicate the key 4 areas that I was referring to earlier. Is this special category data? So presumably your individual service user files will contain special category data, whereas some of the others will not. Is the information shared externally? Is the process included on the record of processing activities? So we can start to see that your information asset register and your record of processing activities are actually connected and indeed could be the same record. Again, if you're a very small organization, you don't have to have 2 separate documents. You can combine it into the one. Then it's about risk assessment. What are the risks? How do we mitigate against those risks? When was the information asset put together? When did we last audit the information asset? And then it talks about data breaches, whether there have been any, etc. So the bulk of the work in terms of your information asset register is the first time that you do it. Subsequently, it's just checking that nothing has changed and then noting when you've completed it. So you start then to fill in the rest of the information, apart from the 4 main categories that I looked at before. And you can see on the example on the slide here, most of it is not applicable. So we're not necessarily looking at masses of work once we've thought through and understood what needs to be recorded. So moving on to your record of processing activities. In essence, this is what you've got, where you got it from, and where you send it to. So it's a list of the confidential data, where it's received from, or where it's sent to, and what's the legal basis for doing this. So you will need to understand whether it's consent or whether it's the provision of health and social care, etc., in order to identify that. And what we need to be doing is making sure that all data in the information asset register marked as being received or shared with other organizations needs to be within the record of processing activities. So hopefully you can start to see the sense with this, that in order to demonstrate that you comply with those legal requirements, you need to be aware of and have a record of what data you've got, where it is, and you also need to have a record of what you do with it. And that's simply what the information asset register is and what your record of processing activities is. So it's forcing you to think through your responsibilities under data protection and GDPR. So similar sort of process here. So thinking through the broad headings that are contained within your information asset register, the bits that relate to staff, the bits that relate to finance, the bits that relate to residents. So the data items that you have within your organization will be listed under each of those headings. And then you can start to identify what you do with those elements and why you do that, what's the lawful basis upon which you do that. So all data that is physically transferred must be on the ROPA, however you do that. You don't need to record information that's through face-to-face discussions or telephone calls, but if you make notes of that discussion, then they need to form part of your records. And the legal requirement for an information asset register and your ROPA is stated within the legislation. So if you have fewer than 250 employees, you don't need to do this unless the processing of that information is not occasional. So therefore it's not just a one-off activity, or if it's likely to result in the risks of those rights and freedoms we talked about, or if it contains special category or criminal conviction status. So clearly, no matter what size you are within a care environment, then it's likely that you are required to have an information asset register and a ROPA. If you've got more than 250 employees, then you need to do it anyway. So the assumption is that most care organizations will need to do this. And just to re-emphasize that the data we're talking about must not be about an individual, but on the high level. So for example, not the individual care records or initial needs assessment of Mrs. Smith, but initial needs assessment generally. So again, similar sort of process, decide what you're going to use to record it, decide on your key groups of data, gather your key information and check that you've covered everything that's on your information asset register, complete the template, complete all the other information, and then get approval for that. So again, you can see the starred elements are the key 4 elements I talked about earlier. And then there's the additional 16 questions that you need to make sure you've thought through and decided whether it's applicable or not. So the data item, the personal data category, is it special category data or just personal data? Is it being transferred in or out of the organization? Where does it come from? Where does it go to? How is it transferred? Is it electronic? Is it paper, etc.? Why is it being processed? What's the lawful basis for doing that? So what Article 6 provision or Article 9 provision are we talking about? Is it special category data? If we are choosing consent, Where is the location of the consent form? What have we done to mitigate any risks to that data? How long are we going to keep it for? When are we going to review this? And is it relevant to carry out a data protection impact assessment on this particular piece of data? So I'm not going to run through that in any more detail. If you need more detail, there is a link on the left-hand side of the slide there through to the Digital Care Hub, where you can access the template and look at the headings and more information in relation to that. So checklist of groups of data items that you can use or not use, if that makes sense to you. So typical sorts of headings that might be within a care environment for you to think about. So once you've identified the item, describe where it's transferred in or out from, describe how it's kept safe. So hopefully much simplified version of what you need to do in order to create your ROPA. And then under those 4 key areas, again, you can see some examples of the sorts of thing that you would expect to see within those key headings. So again, I won't need to run through all of that in great detail, but you will get a copy of the slides that will help you to refer back should you need it. And then again, enter that data into the template, complete the additional questions in order to ensure that you've thought about all of the 20 questions that will show that you have complied with the legislative requirements. And again, just to re-emphasize that once you've gone through that process, get approval. And once you've got those documents, your information asset register and record of processing activities, you're able to confirm question 112 within the DSPT. So that's your information asset register in your ROPA. Data protection impact assessment is the next area I said we would look at. And I would suggest that this is not rocket science for your average care provider. That in essence, what we're talking about here is a risk assessment, but it's a specific risk assessment looking at fulfilling your data protection requirements, and it needs to be carried out at specific times. So let's have a quick run through the data protection impact process and what you need to do and how you need to do it, should you need to do it. So first and foremost, what is a data protection impact assessment? So it's simply a process designed to help you analyze, identify, and minimize the data protection risks of a specific project or plan. So it is a requirement under GDPR, and what it's about is helping you to assess and demonstrate how you comply with those obligations. Again, really important, it doesn't have to eradicate all risk, but it needs to demonstrate that you've thought about the risk, mitigated where necessary, and taken into account the balance between the benefit of what you want to achieve against the risk to that particular confidential information. So it's very much like any other risk assessment that you determine whether or not it's worth taking that risk in order to achieve the objective. DPIs are a flexible and scalable tool. So depending on what the change or introduction of a new process is, you scale it accordingly. So it doesn't have to be complex or time consuming, but we do need to think about all of the elements that we need to think about in terms of data protection, etc. So bearing that in mind, there's no definitive DPIA that we must follow. There is a template available on the Information Commissioner's Office website, and I've included a link on the left-hand side there to that template in case you feel that you want to use that, or you could develop your own template and process to suit your particular needs and your particular organization. However, what you do within the DPIA does need to cover all of the elements that you need to think about. So it is a legal requirement to do so, and it does include certain specified types of processing that are likely to result in high risk to the rights and freedoms of individuals under the Data Protection Act and GDPR. If you don't do a DPIA when you are required to, there are legal consequences, and you could be a fine of up to 8.7 million or 2% of global annual turnover, if that's higher. And I'm sure most care providers would wish that it was. But the important thing is that it's not complicated, it's not difficult, it's just recognizing we have to do it, and we have to demonstrate that we've done it in relation to the processes that we carry out. So a DPIA can cover a single processing operation or a group of similar processing operations. And we could rely on an existing DPIA if it covered a similar processing operation. So if you're working within a group, one DPIA for the group could cover the introduction of a new process or a changed process for the whole group. If you're using new technologies, so for example, if you're introducing digital care plans, a DPIA would be required, but it may be that the product developer has already got a format for a DPIA in relation to other services that they've worked with. But one of the key elements of a DPIA is that it should be part of your data protection by design. So you should be carrying out your DPIA at the start of a process, not part way through or at the end. So when you're thinking, for example, of introducing digital social care plans, the DPIA should be one of the first things you do as part of that project, so you can make sure you build in your mitigations along the way. And just to emphasize with the last point here, that it's important to remember that DPIAs are also relevant if you're planning to make changes to an existing system. So if you're just tweaking what you do and how you do it in terms of processing personal data, then you also need to carry out a DPIA. However, that will probably be much less onerous than if you're introducing a new system or process, etc. So what kind of risk are we talking about that you need to think about then doing a DPIA? So you need to do a DPIA where the processing or the using of the information may give rise to discrimination, identity theft or fraud, financial loss, damage to reputation, or more importantly, loss of confidentiality of personal data protected by professional secrecy. Unauthorized reversal of pseudonymization, or any other significant economic or social disadvantage, or where the data subject might be deprived of their rights and freedoms or exercising control over their personal data. So the key elements within this are loss of confidentiality and the protection of rights and control over personal data in most processes within a care environment. When should you do it? When a type of processing using new technologies and taking into account the nature, scope, context and purposes of the processing is likely to result in a high risk to the rights and freedoms of the individual, then we need to be carrying out a data protection impact assessment. And it makes the point at the bottom again that a single assessment, if it's done correctly, could address a set of similar processing operations. So in terms of what constitutes high risk, there are a number of elements that are identified in Article 29, but I've highlighted in red the ones that are most pertinent to this morning. So where we are processing sensitive data or data of a highly personal nature, where we're processing data concerning vulnerable data subjects, or where we're introducing innovative or new technological solutions. So again, clearly, the introduction of digital social care records will be covered by that. So much of the processing that we do within a care environment is considered to be high risk. Therefore, whenever we change or introduce a new process, I would suggest that we should be doing a DPIA. How do you do it? Well, the first step is clearly to identify the need for one. Then you need to be able to describe the processing that we're talking about. So how are we going to be using this personal and confidential data? Do we need to be consulting with the people whose data that is to check that they're happy with that? We need to assess the necessity and proportionality of the processing that we're considering. Is it appropriate for what we are attempting to achieve as the outcome? And then, as with any other risk assessment, we need to identify and assess the risks that are related to that in relation to the breach of confidentiality, etc., that we looked at earlier. And then what might we be able to do to minimize or remove the risks associated with that process? And once we've gone through that process, we need to sign off and record the outcomes and keep the record to demonstrate our compliance with the regulatory and legislative requirements. I could show you the ICO template at this point, but I think I'll probably stop sharing and just open it up to questions at this stage. So do you have any questions, Charlotte? Did that cover the areas you needed? Okie doke.
Sorry, that's locked the door quickly.
Did you carry out a risk assessment?
Yes.
Right. Well, you will get a copy of the slide, Charlotte.